Good afternoon. Scott Williams here from Hilton Head in Nashville. In case you missed it, Gina Lockwood from Merchants and I debuted a brand new network called SuretyNews at this year's spring meeting in Hilton Head. We hope and expect that SuretyNews will be your #1 source for surety news and analysis. Here's a lead in to the program in case you missed it.
Live from beautiful Hilton Head Island, from the team that brought you hard-hitting investigative reports on project capital and financing structure and its impact on project completion, and issues affecting and impacts of arbitration on the surety and related ethical considerations. This is SuretyNews.
In our debut episode, we provided a special report on judicial bonds, which no one rarely speaks about, but you do hear about them in some dark hallways of law firms and surety claims offices. So just what are judicial bonds? As the chart illustrates, judicial bonds fall into 3 primary categories: appeal bonds, injunction bonds, and what we here at SuretyNews call property bonds. As you can see from the illustration, these bonds are governed by a number of rules and assure different types of obligations depending on the status of a proceeding or nature of the remedy. But the ones you hear about the most and that were the focus of our report in Hilton Head are appeal bonds. Appeal bonds generally fall into 2 groups: supersedious bonds and cost bonds. When a judgment is rendered against a party, that party may appeal the decision, but generally the prosecution of the appeal does not stay enforcement of the judgment unless a party posts security to assure payment of the judgment. This is where the supersedious bond comes in. So it looks retroactively and is generally in the amount of the judgment. In contrast, cost bonds look prospectively and ensure payment of a judgment creditor's costs on appeal if the appeal is not successful. Costs on appeal typically cover the preparation of the record on appeal, but not attorney's fees, but that depends on the nature of the underlying claim in your jurisdiction. For example, some statutes have a fee-shifting provision, in which case it's conceivable that cost bonds could cover that obligation. Turning now to supersedious bonds more specifically, there are a number of rules to consider, but generally speaking, the surety's liability is governed by the terms of the bond. Now, a surety may have an opportunity to draft the supersedious bond, but that typically happens only in special circumstances that we did not have time to discuss during our presentation in Hilton Head. The amount of the supersedious bond can vary as well, but it typically is in the amount of the judgment. Know that supersedious bonds are not automatically enforced. Instead, they are enforced by motion in the same case or by an independent action. In both cases, the surety should get notice and have an opportunity to defend. There are also a number of rules that address these bonds in each of the states, but we focused our presentation on the federal rules because many states track these rules. So the bottom line is, the first step is to read the rules, but that's only part of the story. Take, for instance, our recent interview that we debuted at the conference for your consideration.
Guys, are we rolling? I mean, I'm really uncomfortable here. I really shouldn't be here talking to you guys about this. I shouldn't be saying this. Are you sure nobody's going to know who I am?
Absolutely. SuretyNews has disguised your voice and appearance so no one will know who you are. No one will know that you're tall, no one will know that you have beautiful blonde hair or even this amazing savage tan.
Well, Scott, I appreciate that, obviously, especially coming from a guy of your stature. But the reality is, I'm not comfortable. I want to share this with you. I've got some great insider information that I think everybody should know. I just want to make sure my identity is protected. I want to emphasize there are these rules. And Scott, those are great. But really, if you want to handle these judicial bond claims like a pro, you've got to read the bond form and you've got to talk to people. The reality is sometimes there's some really good stuff in there. And listen, I don't know if you knew, Scott, but the bond form really sets forth the parameters of the surety's obligation.
You don't say. Can you tell us how this might benefit the surety?
Here's an example that comes to mind, Scott. I've been in this game for a long time. I remember in one particular case seeing a claim on an injunction bond. The bond limited coverage to, quote, damages arising from the improper enjoinder of the defendant. Now, here's the thing. The injunction ended up being dissolved, and the defendant's attorney wanted his attorney fees. But there was no court order awarding defendant its attorney fees as damages from the improper enjoinder. So, ultimately, and the reality there is the claim wasn't valid.
Wow, so you got this result simply by reading the bond and the court order. That's an amazing turn of events, Gina.
That is amazing, Scott. Now, do you think that it's possible the court could not be as friendly to the surety's view?
Well, the sad reality there, Gina, is actually yes. The bond will often be deemed to cover what's in the rule or statute with respect to which it is issued. And that can mean, for instance, that the bond covers attorney fees, or urban legend has it that some outlier courts have held. Now, in exceptional circumstances, a surety could be liable for more than the penal limit of the bond.
What? That's blasphemy. Everybody knows it's a cardinal rule the surety's liability should never exceed the penal limit of its bond.
Well, Gina, now you understand. This is why I'm concerned to talk to you guys about this, but I need people to understand. That's what I thought too. But you have to be careful, not only to read the bond, you have to make sure you understand the statutes implicated by the rules and the particular claim.
Let's move on to happier topics. You mentioned that you like talking to other people, which I find mind-numbingly difficult. But you have a different view. Can you elaborate?
Talking to people is the real secret. Talk to everyone. Your principal, the claimant's attorney, other party sureties. It's amazing how frequently talking to other people can help mitigate a loss. Now, here's an example, Scott. Don't forget about the principal. Remember, the principal in these cases is primarily responsible. Principal has been paying an attorney to prosecute the litigation, so your principal might actually be able to take care of the claim without the surety paying. You talk to the claimant's attorney. You might be able to work out a deal, or at least stop the clock ticking on accruing interest, especially if you jump on the claim fast and reach out to the other parties early in the process. Now, here's the thing, guys. Same thing goes for another surety. If there are multiple appellants, for instance, there may be multiple bonds. Now, it may not be clear how an adverse award should be sliced and diced between co-judgment debtors or their sureties. Here's the thing. It's helpful to reach out to the other parties, maybe in that case the other surety, and try to coordinate these issues.
So let me get this straight. Are you saying the surety should just follow its normal claims handling procedures? Investigating the claim, communicating with the principal, obligee, and other relevant parties to handle one of these claims? I thought the surety was just supposed to cut a check and pay.
Well, Gene, I don't want to be condescending here. I might be oversimplifying it just a bit. And really, frankly, that's not what I'm saying at all. I'm saying years ago, long before I had this long blonde hair. Now, not before, maybe Armin Shahinian, but I got a claim on Supersedious bond in the amount of $100,000. And that's when $100,000 was $100,000. Now, in that case, the judgment was affirmed on appeal. The judgment creditor filed a motion seeking recovery on the bond proceeds with the clerk of the district court. The clerk then sent it immediately to the surety. Here's what happened when I received it. I went to my boss. I told him we needed to set a reserve and cut a check. Now, he looked at me like I was crazy. He told me to read the court's order. I stopped dead in my tracks on the way to the water and read the notice right then and there. It said we had 20 days to file a response. My boss looked at me knowingly and said, remember, the principal is the judgment the judgment debtor who is primarily liable on this obligation. We have indemnity from the principal and we have collateral. We have the right to demand that the principal satisfy this, and in fact, he said, the principal may be in the process of working with the other side to do so. Now, turns out, my boss was speaking from a position of reason and experience. That case, the parties filed a stipulation extending the deadline for the surety's response. Now, in about 60 days, the principal and the judgment creditor filed a notice announcing they had settled the dispute and that the bond was released as part of that process. Now, guys, I can't emphasize this enough. I could have made a real mess of things in that case.
You were very fortunate that your boss stopped you, although internal controls at most sureties would have had a lot of questions about that one.
Well, the reality, Scott, is that was in the days before internal controls, so I'm not sure about that. But, you know, I was fortunate in that case that, yeah, my boss did stop me before I made a great mistake. Absolutely.
As you can see, that was an excellent piece of investigative reporting. Gina and I were very fortunate to track down that witness. One thing to keep in mind is the action the appellate court takes can have an impact on the bond. The magic language here is whether the appellant has prosecuted the appeal to effect. The easy cases are those in which the appellant dismisses the appeal or the appellate court affirms entirely the judgment, underlying judgment, in which case the surety is liable, or the appellate court vacates the judgment in its entirety, in which case the bond is discharged. The harder cases involve when the appellate court affirms in part or reverses in part. For instance, if the appellate court affirms liability but remands to prove damages, typically the bond would be discharged. If the appellate court affirms liability but remands to recalculate damages, then the bond could still be, quote, active, so to speak. The bottom line is you need to pay attention to the disposition of the appeal to know whether and to what extent the bond has been discharged or remains active. So the takeaways here are to read the bond, read the rules, understand the remedies sought, and enforcement is not automatic. You should also remember that the principal is the primary obligor. You may have indemnity or collateral, or this may be part of a broader surety program. So the principal may want to resolve the claim to avoid an impact on its surety credit facility going forward. All this means is that a surety investigates the claim using its traditional claims handling procedures and works with all parties to find solutions. This all sounds simple, but we all know that these can be much more complicated, but we save that for a future segment. Which brings us to an important point, and that judicial bonds are discussed in great detail in Chapter 15 of the Law of Commercial Surety and Miscellaneous Bonds. Gina and I strongly encourage you to pick up a copy to read while you relax at your favorite vacation destination this summer. In closing, Gina and I had a lot of help and support for our program and wanted to thank Sam Arena, Julia Lean, Catherine Truman, and Justin Ware for giving us creative license to bring this new network and special report to you. We also had a great deal of help from Merchants Bonding Company and their technical group, and do appreciate that. So thanks for joining us, and hope to see you at the next program.